Welcome to Advocating for Dads with Jana Jones.
Hey there, welcome back to Advocating for Dads with Jana K. Jones. Jana is a dedicated North Carolina family law attorney with over 15 years of experience helping fathers protect their rights and strengthen their relationship with their kids. My name is Kevin Rosenquist, and today we're talking about what happens if your child says they want to live with you. Jana, welcome back.
Hey there, Kevin. How are you?
I'm good. How are you doing?
I'm doing good.
So, interesting topic here for sure. We've talked about this a little bit before. I'm glad to dive further into it. Talking about at what point kids have a say in where they live. What do North Carolina courts actually consider when a child expresses a preference about where they want to live?
Yeah, so the court's job is to determine the best interest of the child when they're determining a schedule and an arrangement for custody. They will take into consideration the desires of the child once the child is old enough to articulate that in a way that the court feels is reasonable. But they prefer not to. And that's because you don't want to put the onus on the child, right? The idea is that the parties should be able to articulate to the court why they feel the schedule they're asking for is in the child's best interest. And that should be that. But you will have occasions where children have strong preferences one way or the other and want to talk to the court about it. And so there's no hard and fast rule about what age it has to be. I've had children as young as 9 talk to a judge before, but I would say more commonly 12, 13 is usually the age where the court is willing to speak to a child. There's 2 ways that you end up as a judge hearing from a child. One is that they get called to the stand as a witness, and the other is that you speak to them in chambers. And the preference for everyone is that a child speak to the judge in chambers because you do not want to put a child on the stand. I feel like that's a really traumatizing thing for the child. And additionally, as an attorney, we really don't know what a child is going to say. And it is very uncomfortable to put kind of a loaded gun on the stand and not be completely sure what they're going to say to questions that you have or questions from opposing counsel. And so the preference is generally that the judge speak to the child or children in chambers, sometimes with attorneys present, sometimes completely just with the child or completely alone without any attorneys or parties present, so that the child feels comfortable enough to actually express what it is that they're wanting to do and the schedule that they're asking the court to consider. I will say that the judges do take that under strong advisement, but it is not a completely determining point as to what the judge does because they still have to consider the child's best interest. And that's more than just what the child is saying that they want. Obviously, a child can be coached, a child can be influenced and manipulated, and the court has to consider a myriad of factors when they're determining best interest. But a child who is old enough to articulate what they want and is very clear on what they want is something that a judge will pay close attention to.
Yeah, I mean, just thinking about that, that would sting also as a parent, if knowing that you're hearing your kid say they want to live with the other parent too. There's so many different factors involved there. The kid might feel bad picking one. There's just so many things that could make it all the whole situation that much worse, for sure.
Absolutely.
Yeah. Why would a court have a child testify rather than speak to the judge? What influences that decision?
Well, the short answer is that both of the parties don't agree. So in a classic scenario where it's mom and dad, if mom says, I want the child on the stand, or I want the child to talk to the judge in chambers, but dad says no, then the only option mom is going to have is to call the child to the stand as a witness. So unfortunately, if the parties do not agree for the child or children to speak to the judge in chambers, then calling them to the stand is the only option if you truly want the court to hear from the child.
I know we've talked about this again, but just in case anyone's just joining us, you said that it's a factor, but it's not the only factor. What factors might influence the decision of where a child would live more than a child's wishes, particularly one that might be on the younger side?
Sure. So I would say the first thing that the court is always considering when they're looking at best interest is stability. They want to know that the child has consistency and stability and safety wherever they're going to be, whichever parent they're going to be with the majority of the time. So the party who is able to demonstrate that they have a plan for, say, education or extracurriculars or healthcare decisions related to the child, that they have appropriate housing and enough room for the child. And say, for instance, if it's two different gender children, a boy and a girl, that each would have their own room, that they wouldn't have to share rooms. Obviously, when children are very young, it doesn't matter so much, but as they get older, they do need their own space if they're different genders.
Mm-hmm.
So those are things that the court is going to be considering and looking at. They're also going to look at which parent's being the most reasonable, who's trying to be the best co-parent. Is somebody just being unreasonable and difficult to co-parent with just because they want to be, and kind of against what's in the child's best interest, right? Withholding information or doing something that they're attempting to get back at the other side, but is actually hurting the child. Those are the things that the court is looking at to determine which parent is going to be the one most appropriate to have primary custody, if that's the decision that the court is going to be making at that point. I will say that the courts in North Carolina, specifically Mecklenburg County, where I practice exclusively, they tend to start with an assumption that joint custody is going to be in the child or children's best interest, because they recognize that the children need both of their parents. So there's no presumption that mom should have primary custody simply because she's mom. The court really is going to be evaluating the lifestyles and the lifestyle that they are providing for the child or children when they're determining what is going to be the best schedule.
We've all seen movie tropes where, you've got kids living with mom or dad, and then there's a blowout or something happens, and then they want to live with the other parent. If a dad comes to you and says, my wife or my ex-wife has sole custody, or has the primary custody, my kid keeps telling me that they want to live with me, what should they do?
So I think the first thing would be to talk to mom, try to see if you can work out amongst yourselves. The reason you come to court is because you cannot work it out on your own. So that should be where you start. Try to have that conversation, maybe test it out and see how it goes for a little while. If they're out for the summer, that makes it pretty easy. If they are in school or it's during school time, then it might make it more challenging if you're not close enough to the school, because that's something the court's going to consider. Again, stability is the most important thing. So if dad lives clear across town, can you get the children to school on time if they come live with you? Or are they going to have to change schools? And is that new school going to be a better school than the school they're currently at? If not, then that's going to play a role. So I would say the first thing to do is to have a conversation with the other parent and see how far apart you guys are. Maybe she's like, you know what? I think that's a good plan. Why don't we let Johnny go stay with you for a little while?
Yeah.
You
deal with this.
Right? Maybe she needs a break.
Maybe,
I know my mama's out here. We need a break. So,
absolutely, yeah.
But if it turns out that no, she's not interested in that at all, then your option is going to be to file for custody, assuming that you don't already have a custody order. If you do, then it's going to be to file a motion to modify custody, asking the court to change your custody arrangement based on what we call a substantial change in circumstances, which is what the court has to find in order to change a custody order. But when you're doing an initial custody action, it's simply best interest. And so if the court determines that it's going to be the child or children's best interest that dad now have primary custody, or maybe that just mom and dad have joint custody, then that's what the court is going to order.
In this situation we're talking about, would a child's desires to switch from living with one parent to another be considered a big enough reason to change the custody?
I would say in and of itself, probably not. But coupled with other substantial change in circumstances, perhaps. So if, the child wants to live with the other parent and recently grades are failing because maybe the parent who has primary custody isn't getting them to school on time, or they're missing a lot of school, or something's going on health-wise with them, or they're having some type of crisis, and maybe that is a result of what's happening in mom's house, then those can be reasons, along with the child's desire, that might measure up to that requirement for a substantial change in circumstances.
Okay, and it's a tricky conversation to have with your ex, I suppose, is to do that. And also, it's if you're telling them, hey, they want to live with me now, I'm willing to do that. That's an emotional Pandora's box, I feel like.
Absolutely. Absolutely. I'm a big proponent of therapy. I think that
Yeah.
families who are living in a new normal where either they were cohabitating and raising the child together, or they were married and raising the child together, and now things have changed. I think that therapy is a really important tool to utilize to work through those issues. Obviously, the law, all we can do at the end of the day is get you an order. That is all the court can do. We can't fix the emotional scars and all of that. And I think that's where therapy comes in, and giving each other grace. It's not easy for anybody to kind of learn the new normal. It's not easy for your child or children, and it's not easy for either one of you.
Right.
Most likely, those parties got together and made this baby and assumed that they would be together forever raising this baby. And so, for that not to be the case, it's going to be hard for everybody involved. And so, I think that folks have to remember that the court is limited to what they can do. At the end of the day, this is not where you come to get retribution or be righteously indignant. This is where you come to get an order, because that's what it's always going to boil down to.
Do you suggest ways at all of like, hey, if someone's like, hey, I'm going to talk to my ex about this, how do you think I should handle it? Do you find like that you have some good advice as far as a better way to do it versus another way?
I think it's difficult to help people navigate that particular conversation, because only your spouse, your ex-spouse, or your ex-boyfriend or girlfriend. No matter how much you tell me about them, I can't really give you a good gauge on how they're going to take that conversation. That's just a hard conversation to have.
Absolutely.
So I think that if I gave any advice beyond talking to a therapist about it, making sure the child is in therapy, talking to the therapist that the child goes to, and try to get some understanding if maybe there's something that the child is telling the therapist that would be helpful for the parties to know in navigating what should be the schedule. Outside of those things, I would say just being honest, just saying, hey, listen, Johnny's come to me and he's saying he wants to try staying with me for a little while. What are your thoughts on that? How can we make this happen in a way that, gives Johnny what he's asking for, but is fair to both of us? Just talking it through to see if you guys can find some common ground. Another option would be to consider maybe getting a mediator involved. So mediators that I work with here in Charlotte are usually family law attorneys like myself, but they also mediate cases. And so that neutral third party can maybe help facilitate a conversation about a change like that, and help the two parties come to a new agreement based on speaking to someone who isn't working for them, right? I'm an attorney. I work for people. So I do not look at it big picture the way a mediator does. The mediator's role is to look at the big picture and try to help people come to a consensus and agreement. So that would be another option that's available to consider when you're trying to navigate what to do when your child's coming to you asking to come stay with you, and that's not been the norm.
Yeah, it's sort of like think like the courts do. What is try to keep the best interest of the child in the forefront, and less about what you may want or particularly feel, and keep it keep it level in that way. So if a dad does try to have that conversation, let's say, and the mom is definitely not interested in exploring this, what's their first step? What kind of things, documentation should they pull together if they want to go down the road of going the legal route?
So I'd say the first thing isn't not necessarily documentation, is having a consultation with an attorney. Really figuring out, based on your specific facts and circumstances, whether or not what you're trying to do makes sense. Because in some situations it will, and it's pretty clear that, we need to file for custody immediately. And then in some situations, there might be a reason to give pause to it first before you go down that road. Or like I mentioned, it might be a reason to go to mediation first and see where you can get there before anybody gets started filing anything yet. I've worked in cases where parties are trying to figure out what to do about a custody schedule, and we go to a mediator first and get all of that resolved in a consent order that everybody signs, and then we file what we call a friendly lawsuit, which really there's no such thing.
I've never heard that before.
Yeah, well, we call it that, but it looks exactly the same as any other lawsuit. But you have to file a lawsuit to get an order. But the idea
Okay.
behind it is we've already got a consent order. It's already been circulated, negotiated, and signed off on. And so now we just need to make it a formal order.
Okay.
So somebody files a lawsuit, and then that consent order gets entered, and now you've got an order. There was no need for litigation or discovery or any of that to happen. You already have your order. And when you have a consent order, that means all the parties agree, and they've been signed off by the parties and their attorneys if they have any, and submit it to the court. And because it's a consent order between the parties, the court is going to sign off on it.
Mm-hmm.
And so that gets you your order. So you've got the formality and the enforceability of an order, but you didn't have to actually litigate. So that's an option is available as well.
Mm-hmm. Yeah. Okay. All right. Well, thanks for joining us today on Advocating for Dads. If your child is asked to live with you and you're not sure what your rights are, start with a consultation at lawofficeofjkj.com. Jana can help you navigate the legal and emotional realities of this decision, give you the advice you need. Don't forget to leave a review, subscribe. Don't miss an episode. We got lots more amazing content coming your way. Jana, always great to see you. Thanks so much.
Thanks, Kevin. Take care.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.